Hello. Shall I? Good afternoon, one and all. Yes. So you know the subject? I International trade law. Yeah. So before that, you need to understand that we need to discuss what is international trade. Okay. So have you ever heard about international trade and all? Yes. It's somewhere you can see in the international law itself. No. So we will first discuss about what is international law, sorry, international trade. After that, we will discuss these things like we have what are the types of international trade being in existence, then what are the benefits, and then international trade law, then theory, sources, UN convention, then international sales of goods, then FDI is there, transactional companies, corporations are there, then e-commerce is there, and international taxation and risk analysis. Okay, so we are just discussing all these topics. So first of all, if we discuss about international trade, what does it mean? How to go to the next page? Next page. Okay, okay, this side. So we know that in international trade, what is called trading? It's something like what? Transaction. So if we have sufficient amount of thing or sufficient amount of capital, then what we do? We make those substance and we make those products and we will transfer it to another country. Okay. So basically this international trade involves what? Export and import. That's what we call exportation and importation. Okay. So we know that there are many factors which have been involved in production and all. Like labor is there, capital is there, and natural resources is there, raw materials is there. So these are things can be said to be the factors of production. So we know that every country is not self-sufficient. There must be some kind of lagging and all. While if you take example of India, maybe we have some kind of problem relating to what? Capital. Or if we have some kind of problem related to natural resources, and if we have some kind of problem related to technology, lack of technology. So what we will do? We will seek the help of other countries. So we will import things which we are lacking and we will export the things which we have in abundance. So that's the main thing which is known as trade. And if we speak about the same thing in international level, it will be termed as what? International trade. So this international trade, if we define it, we can say that no country can be self-sufficient. Okay, so we need to import something which is lagging. Okay, and we will export in which we have in abundance. So in that sense, we can say that there are mainly two types of trade. Okay, we have bilateral trade and multilateral trade. So what does this bilateral trade means? If we are trading with one country, that is, we can say that is a mutual trading. If country A is there, country B is there, and A is trading something to giving something to or trading something to country B, and B is giving something in exchange. Okay, this is called bilateral trading. And if we speak about multilateral treaty, what does it mean? It means one country is having trade relation with number of countries. It is not multi. You have learned that in international law it's like multilateral treaties. Okay. So one of the example for this multilateral trade is that is the United States Mexico Canada agreement. Here all what states are involved? United States is there, Mexico is there, Canada is there. So they have formed an agreement through which they are transferring or they are transacting some kind of product. So that is known as trading. Okay. Then, coming to the next point, that is, if we are doing certain kind of trade, what is the main motto or what is the main object behind doing some kind of trade? Yes, we all do for profit, isn't it? So that is, every country needs profit or some kind of wealth or some kind of capital for their economic development. Okay, so that so far we speak about the developing country like India, we need many much help or many much profit. Okay, so that we can develop our economy and we can make it in a static level. So the main idea behind or the main motive behind such a trade is what are the benefits? We can generate more income and also more choices for consumers will be there. That is, we don't have to depend upon the things which have been made domestically. Okay, we can purchase. We have many options like we can purchase things which are being branded one. Like if we want to go for any German product, we can purchase that. So there are more options before us. Okay, so it creates some kind of choices for the consumer. And then obviously economic growth will be there. If we are doing trade, no doubt profit will come and it will amount to some kind of growth. Okay. And then effective utilization of resources. So if we trade, we are somewhat utilizing our resources, whether it may be natural resources or it may be labor or whatever it is. So we are somewhat utilizing it. So the utilization of resources is happening. So it is a one kind of benefit which has been attained through this kind of trading. Then exchange of factors of production. So factors of production like we can do the labor exchange. Then yes, infrastructure will be there. Technology we can exchange. Raw materials we can exchange. So all these things can be done, and this kind of benefit can be attained through what? International trade. So this is the main concept behind trading. And if we are going further, or if we are going to discuss about this international trade, first we have to keep in mind what is international trade that is being discussed. Okay. Uh, International trade law. While coming to international trade law, why we need a kind of law? What is the main motive or what is the main reason behind forming a law? What is the main purpose of law? In every area, we can see that there must be some sets of rules, some sets of regulations, and some sets of code of conduct will be there. All these are being there because we need in our day-to-day life. In every area, we can apply law. Without law, we can't do anything. Okay, we can't do anything in a disciplined manner. Okay, this trade was the international trade, or we speak about the trade after the World War II or after the globalization. We can see that many countries are doing trade and all, but they don't have a particular set of rules. Okay, somewhat they will follow the domestic rules. Okay, see, somewhat will become contradiction to the laws of another country. So, in order to maintain justice, fair, and equality with some natural laws, it came to the mind of various nations that there must be a set of uniform law so that the same law can be applied while we are doing trading. Okay, so keeping that in mind, conventions have been formed and various treaties have been formed. So from this convention, the sets of rules and the sets of regulations being made so that if any country is doing trade with another country, they can use a general rule so that no country's domestic law will become contradict to each other. So keeping that in mind, this international law has been formed. And we can say that this international law is a tool used by a nation's government for taking corrective action against trade. So that was the main motive behind the formation of this international trade, in order to form a set of rules or set of regulations so that the nation or the world can transact or the world can do trading without making any contradiction with the domestic laws of any particular nation. Then what does it include, which is already been mentioned, like rules, regulations, and all the things that will be there. Okay, so let's come into the theory part. We have something called mercantilism. Mercantilism means it's a Latin word which means specifically it means a merchant law. Because we can say that if we speak about the history of the trading and all, it has been done earlier. Okay. And it was mainly done by the merchant groups. So that's why they formed the kind of law which has been practiced between them. That means between the merchants itself. So that's why this mercantilism came. The concept of mercantilism came. That means the merchant law. Okay. So we can say that every law has been formed from some kind of theory. You have learned in jurisprudence and all, you have seen that the law had its origin from some kind of theory. Some things have been interpreted by the jurists and all, and finally they will become a kind of law, like we speak about some kind of precedents and all. Okay. So this international trade law itself is formed from or has its basis from some of the theories, has been derived or has been formed from some kind of theories. And this mercantilism is one of an ancient origin, or we can say that one of the ancient theories from which this concept has been came out. Okay. So we can say that it is an economic policy that is designed to maximize the export and minimize the import for an economy. So what is the main purpose behind maximize the export and minimize the import? See, if we are doing more import, what happens? But our capital will go down, reduce capital, reduction of capital will happen. So and what happens if we have plenty of exports and all? We will get more income. Okay, our economic stability will be in a harmony. Okay, so the main concept behind mercantilism was to do what? To encourage what? Export. So in order to maintain the economic growth. Okay. So that was the main concept behind mercantilism. That was one of the theory. And coming to the next theory, that is absolute cost advantage theory. What does it say? It says that the ability of a business to produce more. That is, they are giving the facility to produce more and then to sell more or goods or services with competitors using the same amount of resources. Adam Smith proposed this theory. So the main concept behind this absolute cost advantage theory was that if country A is there and another country B is there, what happens is that if country A is making something which is more than the country B, while both the countries having the same capital or same resources, while country A is producing more or abundant while comparing with country B. So this is a kind of absolute cost advantage theory. It encourages the country to produce more and to sell more. Okay. Just want to go back. Excuse me. Excuse me. I just want to go back to the previous slides. I just don't understand this one. This, yeah, yeah, okay, okay, okay. Yeah, yeah, yeah. Then coming the comparative force theory. This was another theory. It is the ability of a party to produce a particular good or service at a lower marginal and opportunity cost over another country. So here we can see that the concept of these theories are somewhat similar. Like if country A is producing something which is in abundance while comparing with country B while they having the capital resource C. And here what is that? What happens is that some countries producing what? Something which is lower in marginal, okay, while comparing to another country. So what happens is that they will get more opportunity to get their products exported, being exported. So that is the concept behind the comparative cost theory. That is, they are using the cost very less and they are producing much. Okay, so this is being given under this theory. And when coming to Hester-Rollin theory, what does it says is that the same thing. That is, if a company, sorry, if a country has a capital less, so they what will they do? They will import things where they can get more income. Okay, and they will export what they have in abundance. So if they have more capital, they will do more capital uh, facilitated imports, and they will import what they are lagging. So that's the main thing which is laid down under Hester-Olin theory. Then, while coming to let's Mercatoria, it is a system of law for dispute resolution in international trade. So here in this theory, we can see a mechanism called dispute resolution mechanism. Because if we are doing a certain kind of trade and all, it happens like some kind of dispute will arise. Because two different countries are dealing with, okay, they form some kind of agreement, they form some kind of contract, and they are doing the trade and all. So there must be a kind of possibility that some kind of dispute may arise. So that kind of dispute may be resolved. Okay, so there must be some kind of addition of like arbitration clause will be there so that the dispute will get resolved by itself. So this theory consists of that provision that if any kind of dispute arises, then the concerned country can go for what? Arbitration. So this theory provides provision for what? Arbitration clause. Okay. So when coming to the sources, we all know that every law has a sources. Okay, like if you have studied the jurisprudence and all, the sources of law is there. So likewise, international trade law also has some kind of sources from which it has been formed. And these are the some kind of sources from which the international trade law has been formed. Okay, so treaties, obviously treaty is there because what is a treaty? Treaty is an agreement. Okay, it can be formed from some kind of conventions and all. And the main motive behind this treaty is what? In order to maintain some kind of discipline between the nations. So from this international law has been formed. Then international commercial practice, like you can see that before the formation of this international trade law, some kind of what? Some kind of commercial practices will be there. You know that the customs sometimes if it has some kind of weightage will amount to law. Okay, a custom can outweigh law also. So some that likewise there must be some kind of experience, some kind of customs being in practice in commercial area. So that practice itself can be one of the source for international trade law. Okay, so treaty can be, and another one is what? This commercial practices. The practice can also be converted into law. Okay. The general principle of law. General principle of law is what has been uniformly stated. Or we can say that the natural law will be there. Or the general principle of law is like that we are treating something with fair justice and reasonableness. Okay. So that must be there. So something has been taken from this also. And Lex Mercatoria is there, which has been also we discussed in the theory part. So it will be there. Then of course the domestic laws. So domestic laws we have learned that private and public law is there. So from all these sources, there is a combined form or there is a general set of practices, set of rules which have been formed, which is later termed as international trade law. So these law or these customs which have been practiced in the commercial area then attain the form of the law, which is later termed as international trade law. So these are the sources. Then coming to the next part, that is UN Convention. So obviously, we have discussed in the source part that treaties will be there as one of the source. Okay, so how the treaties have been formed? Why we need a convention? What is the need of a convention? If there is any kind of practice which has been going in a world or across the globe, and we don't have any particular set of rules or general law for the same, then what happens? The thing will come under what? Discussion. And for that, many countries will take a part. They take part and they will render their suggestion and they give their opinion, and finally we will get a particular kind of guidance or guidelines or direction for that particular thing. So for that, this conventions have been formed. So with related to this international trade law, we have UN Citral and Unified Principle, which has some kind of rules and regulations that regulate the international trade law. Okay. So when coming to UN Citral Convention, what does it say? Is that the full form of UN Citral is what? United Nations Commission on International Trade Law, UN Citral. So what is the main motive behind this UN Citral? It is a subsidiary body of UN. Okay. It has been formed by the UN General Assembly and it is responsible for facilitating what? International trade and investment. So their motive is to promote what? International trade and investment. Okay. And it is established by United Nations General Assembly in 1966 and UN's official mandate is to promote the progressive harmonization and unification of international trade law through conventions, model laws, and other instruments that addresses key area of commerce from dispute resolution to the procurement and sale of goods. So what is the main purpose behind the formation of this UN Citral by United Nations General Assembly? It provides facilities or provisions for what? Harmonization. Okay. And it provides some kind of sets of law, model law, general practices. So that the same provision can be taken for what? For international trade law while we deal with international trade law. And this UN Citral carries out its work at annual sessions held alternatively in New York City and Vienna where it is headquarters. So the sessions have been conducted here at New York City and Vienna. Its headquarters is in Vienna. Okay. Then some of the major conventions related to this UNICITRAL. So the convention happened and the convention mainly consists of what? General principles of law, model law, some sets of rules and regulations and all. Okay. And on the basis of that, certain conventions have been formed. And what are the various conventions with regard to this UNICITRAL are this. Convention on the recognition and enforcement of foreign arbitral award, then convention on the limitation period in the international sales of goods and so on. So many conventions have been formed under the guidance of what? UN Citral. The next is UNIDROIT principle. What does it say? It is formally the International Institute for Unification of Private Law, an intergovernmental organization whose object to harmonize international private law across countries through uniform laws, international conventions, and the production of model law, sets of principles, guides, and guidelines. So somehow we can see that this convention resembles the same because these two conventions have what? Some sets of law. They are also saying that some sets of laws are there, model laws are there, general law principles are there. So these conventions discuss about those things like the sets of rules which can be uniformly applied in the case of doing what? International trade. Okay. So it is established in 1926 as a part of the League of the Nations and it has got multiple conventions and soft laws. What do you mean by soft law? Have you ever heard it before? Soft law. It means some kind of code of conduct and regulation. We can't say that it is have a legal enforcement or like that or a validity or like it is not something called valid, something called mandatory. Okay. So some soft laws are also there and some multiple conventions has also been formed. So the seat of UNIDROIT is in Rome, Italy, and under this UNIDROIT we can see various conventions also, like uniform law on the international sale of goods, and then uniform law on the formation of contracts for international sales of goods, then convention on travel contracts, convention on international financial leasing. So we can see all these areas coming under what? UNIDROIT convention. Okay. Then the next part is harmonization and unification of the international trade law. So what does it mean? What do you mean by harmony or unification? Harmony is what? Yes, in order to maintain a kind of peaceful relationship. Okay. And unification means what? To unite. Okay. So make something or to prepare something which is what? To unify something and to do what? And to create it which through which a harmony can be created. So what the main function of this harmonization and unification of trade law means is that to provide some sets of rules and regulations which would create some kind of harmony or some kind of unification of some sets of laws so that the same can be applied across the world without having any kind of illegality or any kind of contradiction in, with regard to any kind of particular nation. Okay. And coming to the next, transactional companies. You have heard about multinational companies, global companies and all. Then transactional companies means what? What? It has its headquarters somewhere, but they are doing, yes, operates throughout the world. Like if you go for an example, we can have plenty of examples. Like Coca-Cola is there, McDonald's is there, then Apple is there, Microsoft is there. So there are plenty of examples for that. So these are transactional companies. Okay, it means that their headquarters is somewhere else, but they are operating their business around the world. Okay, something we can say that it can have a geocentric approach. It has some kind of rules so that they are governing through the world. So one of the striking feature of transactional company is that it distinguishes from global company that it does not consider any country as its home country. So it does. So it is the peculiar nature of this transnational company. It does not consider any particular nation as its home country because it is spread across the world and doing their business. Okay. Then coming to FDI. So it is also you have heard about this before, right? What is FDI? Foreign direct investment. So whether foreign direct investment can be treated as a profit or treated as a positive, we can take it as a positive thing with related to a developing country. Yes. Why? Because FDI creates what? They receive investment from foreign countries and it at the same time creating what? Or kind of economic development to a particular country. So obviously, this FDI can be a what benefit with regard to any particular country. So FDI, it's a foreign direct investment, and investment made by a company or entity of a country into company or entity of another company. That is, one state is making, one state is giving its investment or deposit over another company. So it is something which is extraterritorial. Okay. And non-resident investor invest in resident nation. That is, a foreign country is investing. So that is known as what? FDI. So that is a foreign country is making investment to another country. So FDI may be done by an individual, business entities or government. Okay. Then if you come across with advantages and disadvantages, we have the lists of what advantages and disadvantages. So if we go through that, we have what advantage part flow of foreign money. Obviously, FD will create what? Yes. An increase in employment, of course. And domestic producers become more efficient. So it will give what opportunity to the domestic producers as well. And then inflow of equipment and technology. Okay, and increase productivity and increase export. So it will somewhat help to promote what? Exportation and involve to create what? Economic growth. Right? Everything has the advantage part and disadvantage part as well. So if we have this much advantages, we have some sort of what disadvantages too. Like domestic company will suffer, they are less competitive because they become less competitive. Okay, if they are doing MDI and all, because they see that if there is no competition, so they will what happens? They will become inactive. Yeah. So in that sense, they become less competitive. And effect on natural environment. So how does it affect our natural environment? How can we say that the FDI will create or if it affects our natural environment? Yes, if it is like if we are doing investment and all, we can increase our economy. Okay, the country will give more what investment and all. So if there is something like if they are doing, somewhat it creates some kind of less competitiveness among the what countries, and that it will in turn what causes it will in turn cause the less usage of the natural resources as well. So the natural resources, if we have plenty of natural resources, and you are not making use of it at all, then what will happen? Effectiveness, or we will somewhat lose the what the natural resources, the proper utilization of natural resources as well. So what happens? The natural resources become ineffective. Okay, so these are the disadvantages of FDI. Then coming to the next topic, that is international commercial contract. So you have learned contract, yes, in your previous classes. So what is the contract? It is an agreement between the parties, and for some kind of consideration will be there. So if we speak about what commercial contract, what does it mean? Something or some kind of agreement or contract which has been done in the commercial area. Okay. And if it is international commercial contract, then what does it mean? It means that a country has made some kind of contract, commercial contract with another country. It is something which is above our territory, something which is extraterritorial. Okay, so we are making some kind of extraterritorial contract in a commercial field. So that is termed as what? International commercial contract. Okay, we can see that in contract many aspects are there, so many facts are there. All those things are also being included in this commercial contract as well. So what is international commercial contract? Are sale transaction agreement between parties from different countries. It is what already said, that is something which is extraterritorial. So one country is making an agreement or contract with a sale of goods contract with another country, then it is what? It is a commercial contract which is being done in an international level. So that will be an international commercial contract. The international instrument have identified contract as international when the parties concluding the agreement come from two or different states. So that's the same thing we discussed. If the parties to the contract is from different countries, then it is obviously what? It is international contract. Okay. And if it is done for only for the commercial purpose, it will be international commercial contract. So some of the things has been discussed in the Hague Principle and CISG. So the concept behind or what has been stated in the Hague Principle regarding this this commercial contract is that one approach to identify a contract as commercial may be where each party is acting in the exercise of its trade and profession. So according to that trade and profession, we can identify whether that particular contract is what? Commercial contract or not. Okay. So from the trade or profession itself, we can identify whether a particular contract is commercial or not. So that is the procedure, that is the thing which has been discussed or which is stated in Hague Principle with regard to what? Commercial contract. Then examples have been given, like another approach is found in CISG. CISG means Convention on International Sale of Goods. Okay. So it has given some limitation to the applicability of this commercial contract. It says that yes, contract can happen between individuals. So if we speak about our Indian Contract Act and all, we say that contract between two parties. But it is a international commercial contract. It means it has been done with two different nations. But the CISG has limited its scope to a certain extent that something does it comes under commercial contract. What are those areas? Consumer contracts, then those good bought for personal, family or household purposes. So if any contract has been made with regard to personal benefits or which has been done for household activity, all those contracts doesn't comes under the commercial field. Commercial means what? Which is particularly done in the commercial area, and which is not something which is related to personal or family only. So that the CIC has awarded those contracts, that those contracts have not been included in commercial contracts. Okay. So international insurance, IPR, transfers, franchisee or agency contracts also fall within the complex of international commercial contracts. Some of the examples have been given. And the international insurance will be there. If one person is traveling from one nation to another nation, insurance will be there. Okay, IPR, intellectual property rights. So all these things have been, that transfers. So all these things comes under this kind of contract at all. Then United Principle of International Commercial Contracts 260 and reference to as PICC, that is Principle on Commercial Contract. Okay. There 211 rules for international contracts. So under this, what this unitried principle, we can see that in PICC, some set of 211 provisions have been given. So these provisions deals with what? These provisions deals with commercial contracts. So how the commercial contract has been done, what are the procedures need to follow, and what all things comes under the commercial contract and all. So the provisions and all we can see in PICC 2016 Act. Then next topic there is international sales of goods. You have heard about sales of goods and all in previous classes. Okay. So what is the sale of goods? What do you mean by sale of goods? Selling mobile property. Any goods. So while if we go to the international concept, we can say that sale of goods contracts have been acknowledged as the basic foundation of international trade, because in trade what happens? We are actually selling. No. Yeah. So in that concept, it is somewhat the we have to go through the sales of goods act and all, but not which is being governed in our area, because there is something which is in general principle. Okay, international sale of goods is there. We have to follow that principle, because domestic law we can't apply when we are trading in different countries. So that concept has been given. So the sale of good is one of the important feature or element of what international trade. Because in trade, what we are doing, we are selling things, or we are just exporting. Exporting in the sense we are giving them. Giving them means what? We are selling them. Okay. So such thing will happen. So International Sale of Goods Act will also govern the international trade law as well. So an international sale of goods contract is an agreement whereby the seller transfers or agrees to transfer the property in goods to the buyer for a consideration across the border. So the same thing happens in the contract. Happens. Is it true? So consideration will be there, no? Yeah. So the same thing is also applicable here. And for international sales of goods, the body of law will be often be the UN Convention on Contracts for the International Sale of Goods, that is CISG, known as Vienna Convention, because we know that a particular area law or a domestic law of a particular area cannot be applied in the case while we are doing international trade. So for that we need to have some sets of rules and regulations, and that sets of rules and regulations has been provided under this Convention on International Sale of Goods. And we are using the provisions while we are doing this international trade. Okay, so those principles have been applied in the case of international sales of goods. Then CIS is sometimes known as the Vienna Convention, is a multilateral treaty that establishes a uniform framework for international commerce. Okay, so it's nothing like it creates certain general rules, some sets of general rules, so that the trade can be done without having any kind of irregularity and illegality with respect to a particular nation. The purpose of CIS is to facilitate international trade by removing legal barriers among the contracting states, because we know that every country has their own domestic laws. If every country will follow their rules while contracting with another nation, it will create some kind of disparity, some kind of dispute and all. So we can't do that. So for that we must have a set of general laws, so that we can use that sets of general law and can do the trade. Okay, so that can be used. So the party to this international sale of goods, that is 90 countries have ratified this treaty, including big trading countries like USA, China, Singapore, Germany, etc. Okay. Coming to e-commerce. E-commerce means electronic commerce. Okay. Nowadays we are doing what? There is a trend, yeah, online business. Online trading is there. So what happens was that we are very well know about the traditional paper-based method of contract and all. Like we are doing the signing and we are doing the records and the writings, everything, witness and all. So, but in this fast-paced society, we need on the part, for a developed country or for a developing country, a new trend has been came, that is e-commerce or electronic commerce or electronic trade, we can say that. So we can do the things very fastly. Okay, there is no need to wait for a long time with regard to any kind of specific contract. If we do paper-based or traditional paper-based method of contract, there must be some kind of lagging and all. And here the electronic method, we can do the things very fastly so that we can send our agreement we can send our signature through this electronic mode to the person who is staying abroad country. So here we are doing the transaction or the trade from one country to another country. So if we are doing a contract with that country and if we are following the traditional method of contract, it will take time. So that's the reason why this electronic made commerce has been introduced. So the sender's consent, acknowledgement, and everything has been stored in a data message. And this data message can be used as evidence if in case this contract creates any kind of disputes and all. Because we know that if we make any kind of contract, there will be possibility of what disputes and all. So at that time, we need to produce some kind of evidences. So here, if we are doing this electronic mode commerce, we can save these data messages as evidence if there exists any kind of what disputes. Okay, so that is the new trend. So transactions carried by electronic data interchange and other means of communication, commonly known as electronic commerce, that is e-commerce. And the United Nations Commission on International Trade Law, that is UNCITRAL, the means of modern law and electronic commerce, that is MLEC, sought to provide a set of internationally acceptable rules with an aim to remove legal obstacles and increase legal predictability for e-commerce. So, if we move towards a new trend, it happens like some kind of issues will generate. Okay, we can't say that it is proper in all sense. Some kind of disparity may arise, some kind of issues may arise. So this electronic commerce has been given. They are following certain sets of rules and provisions from this UNICITRAL and this modern law on economic commerce, so that they can use these things on the e-commerce as well. Okay, so they are providing provisions with related to e-commerce as well. So UNICETRAL and the model on economic commerce are there. They are providing or they are facilitating some kind of provisions so that this e-commerce can adopt and they can do the trade very easily, or they can do their business or transaction activity, whatever it is, very smoothly. Okay. The model is not a comprehensive or like articulation of the rules of the electronic transaction. So it is not comprehensive. Comprehensive in the sense it means that it consists of what? It consists of sets of uniform laws. It can be said that it is a settlement agreement where the rights of the parties has also been mentioned. So this model laws are also being applied in what? E-commerce. So it adopts a limited framework approach and enable and facilitates e-commerce. So some of the fundamental principles of modern electronic commerce have been given. So what are the benefits of this e-commerce? First is principle of non-discrimination. So principle of non-discrimination is what? There is no discrimination has been made. Okay, fine. So shall I conclude? Okay, so we will take the next question tomorrow. Okay, thank you. Thank you. ഈ പണ്ടാരൊന്ന് ക്ലോസ് ചെയ്യോ ഇതൊന്ന് ക്ലോസ് ചെയ്യോ ഞാൻ എന്റെ ഇതെടുത്തോട്ടെ सर how was it sir अच्छा था really sir झूठ मत बोलिएगा ठीक था അതല്ല ഇവിടെ ഇത് ठीक था ना सर क्योंकि ये सब्जेक्ट मैंने कभी पढ़ा नहीं है पढ़ाया भी नहीं है ओके सर थैंक यू क्लास में सर पानी पीती हूँ या
Sir, try. உங்களுக்கு எந்த ட்ரை? எந்த ட்ரை? இது எடுக்கணும். இது ஸ்பீக்கர். இல்ல, இது இன்ஸ்டால்மென்ட்ஸ். எங்க இருக்கு இன்ஸ்டால்மென்ட்ஸ்? வந்து அது எங்கப்பா? இல்ல. இல்ல. இது இல்ல, இது இல்ல. இது இல்லையா? இது இல்ல. அதுலப்பா. இங்க வா. இந்த பக்கம் வந்து மாட்டி பக்கம். இதுதான் இன்ஸ்டால்மென்ட்ஸ். அப்படி இல்ல. PPT sir. Right, that's good. இது ஓபன் பண்ண இன்ஸ்டால்மென்ட்ஸ் ஓபன். எடுத்துட்டு போட்டு பாருங்க. நீங்க கிளாஸ் எடுங்க. ஓவர்லாப் இதுக்கு முன்ன கம்ப்ளைண்ட் பண்ணுங்க. சொல்லி அது உள்ள பிபிடிஸ் இருக்கும். இதுக்கு முன்ன அந்த பக்கம் ஃபர்ஸ்ட் டைம் போடப்ப சைடு வந்து லாஸ்ட் எங்க வரும் இன்சால்வென்சி வரும். Yeah, please. Yeah, please. Right. So, madam போன உடனே கிளாப்ஸ் அடிச்சோங்க. ஏன்னா நீங்களும் போலான்னு சொல்லிட்டா. Still you have to wait for another half an hour. Right? Yeah, another subject is there for you. I think all of you are honors only. Right, you are having another, it's a purely procedural law that is known as insolvency and bankruptcy laws. Bankruptcy and insolvency laws is therefore laws is there. Right, we will see the genesis of this insolvency and bankruptcy laws. If you remember company law தெரியுமா? எத்தனை செமிஸ்டர்ல வந்தது? Right, for 3 years, third semester. Right, now if you want to register the company, you have to go before registrar of companies. If you remember, ஒரு கம்பெனி ரிஜிஸ்டர் பண்ணணும்னா நீங்க ROC கிட்ட போய் you have to file memorandum of association, articles of association. Right, you can start the company. Now if you want to close the company, where you have to go? High courts. That means ஒரு கம்பெனியை க்ளோஸ் பண்ணணும்னா எங்க போன நீங்க? high court ku poyi you have to get the permission from the respective high courts, right? Now it's a big process is there. Now subsequently they have enacted one separate act, or separate act கொடுத்து என்ன சொன்னானாத்த insolvency and bankruptcy code 2016 ஒரு புது சட்டம் கொண்டு வந்திருக்கா. சிபிசி மாதிரி, சிபிசி means civil procedure code, right? That is apply for civil suits. Like this, they have bought another code that is known as insolvency and bankruptcy code 2016. இப்போ any company if it wants to close down, any company if it wants to liquidate, they have to do the process under insolvency and bankruptcy code. இதுக்கு முன்ன old actல நம்ம எங்க போயிருந்தோம்? Companies Act you are going, but under the new act you are going before insolvency and bankruptcy code 2016. நாகின் வரலையா? இதுக்கு முன்ன அங்க சைடுல வந்து நாகலே. Right. So you have to go before, you have to follow the insolvency and bankruptcy code. Now, yeah, please. High court jurisdiction has been taken away. இப்போ high court க்கு powers கிடையாது. எதுக்கு powers கிடையாதுன்னா company close பண்றதுக்கு high court don't have powers, right? Now the power of the high courts has been given to, yes, Companies Act க்கு separate courts establish பண்ணா. Previously if you want to close the company you have to go before high courts. Now if you want to, again if you want to register the company, process is same under the Companies Act, process is same. If you want to close the company, if any issues are also there, for example transfer of shares, transmission of shares, previously company law board is there, from company law board you are going before the high courts. இப்போ ஹை கோர்ட்டுக்கு பவர் கிடையாது. யாரு கொடுத்தா பவர்னா, எஸ் எஸ் வேர் இட் இஸ், ரைட், யா. இப்போ ஹை கோர்ட்டுக்கு பவர்ஸ் கிடையாது. You have to know this. High court don't have power under the Companies Act now. Who is having power means NCLT, National Company Law Tribunal. You have to remember NCLT. From NCLT you have to go before NCLAT, National Company Law Appellate Tribunal. Now the jurisdiction from National Company Law, right. National Company Law Appellate Tribunal, appeal lies to Supreme Courts. That means now the High Court don't have jurisdiction with respect to a company. Where you have to go? You have to remember NCLT, NCLAT. They are known as adjudicating authorities. என்ன சொல்வாங்க? Adjudicating authorities, right? Now you are having two concepts is there, bankruptcy and insolvency laws. Now we have to see the meaning of bankruptcy, meaning of insolvency. For example, சிவில் சிபிசில உங்களுக்கு ஒரு சூட் இருக்கு தெரியுமா? இண்டிஜென்ட் சூட் கேள்விப்பட்டிருக்கீங்களா? என்ன இண்டிஜென்ட் சூட் அண்ணா? வெரி குட், பாப்பர் சூட். உங்ககிட்ட காசு இல்லைன்னு சொன்ன யார் டிக்ளேர் பண்ணணும்? கோர்ட் டிக்ளேர் பண்ணணும், ரைட்? அதே மாதிரி கம்பெனி கிட்ட கூட காசு இல்லைன்னா யார் டிக்ளேர் பண்ணுவான்னா? கோர்ட். இங்க கோர்ட்னா யாரு? NCLT, NCALT, ஹை கோர்ட் கிடையாது. First one is insolvent. Insolvent என்னன்னா it's a temporary situation. ஒரு கம்பெனி இருக்கு, company is dealing with so many suppliers, so many what is called service holders. Company is dealing with employees also. Now supply பண்ணவன என்ன கேட்பான்? காசு கொடுன்னு கேட்பான். எம்ப்ளாயிஸ்க்கு என்ன கொண்டு கூட நீங்க you have to pay salaries also. Now, if you don't pay salary in the month of January, you can pay in the month of February, March, right? That means it's a temporary situation, right? So now, if the situation is going on for a long time, உங்ககிட்ட காசு கிடையாது, சப்ளையர் கொடுக்கறதுக்கு காசு கிடையாது, you don't have money to pay to the employees, then you have to go and approach the NCLT, and NCLT passes one order that is known as discharge order. That means உங்ககிட்ட இன்னும் காசு கிடையாது, it will declare the company as insolvent. That means bankruptcy is a temporary situation. It can be corrected, while insolvency is the permanent discharge of your debts. The NCLT will say, now onwards, you are a bankrupt. That's it. உங்ககிட்ட எனக்கு காசு கிடையாது. Nobody should ask you the money. Who has to give that order? Adjudicating authorities, that is NCLT. Now, let's go into the concepts. Right. Insolvency is a state when an individual, corporation, or other organization cannot meet its financial obligation for paying debts as they become due. கடன் வந்த உடனே கொடுக்க முடியாது என்ன சொல்லுவாங்கன்னா insolvent. It's a temporary. It can be rectified. Bankruptcy is not exactly the same as insolvency. Technically, bankruptcy occurs when a court has determined insolvency and given legal orders. நீங்க எப்படி இண்டிஜென்ட் சூட்ல இன்சால்வென்ட் ஐபி வச்சு கோர்ட்டுக்கு டிக்ளரேஷன் வாங்குறாங்களோ அதே மாதிரி இங்க கூட என்சிஎல்டி முன்ன போய் என்கிட்ட காசு கிடையாதுன்னு சொல்லி யூ ஹேவ் டு கெட் a legal order, thereby discharging your debts, right? Now, two types of insolvency has been recognized under this code. Insolvency and bankruptcy code here, two types of insolvency. One is corporate insolvency. Corporate insolvency enna company insolvency. Another one is individual insolvency. One the corporate insolvency, another one is individual insolvency, right? Now, with respect to individual insolvency, அது கூட எந்த சட்டம் இது பண்ணோம்னா insolvency bankruptcy code, but provisions are not yet notified. இந்த provisions notify ஆல. Individual insolvency அண்ணா civil court க்கு போய் you have to file an IP petition still. Once notified, you have to come under this code, insolvency and bankruptcy code, right? Now you know corporate insolvency determined by NCLT, NCALTs. Individual insolvency ki நம்ம முன்ன எங்க போனோம்னா நம்மளுக்கு two types of laws are there. One is Presidency Town Insolvency Act, another one is Provincial Town Insolvency Act. இப்போ நீங்க ஐபி ஃபைல் பண்ணணும்னா எந்த கேஸ்க்கு போனோம்னா மெட்ராஸ், சென்னை, கல்கட்டா, மும்பை அண்ணா பிரசிடென்சி டவுன் இன்சால்வென்சி ஆக்ட் யூ ஹேவ் டு கோ. ரிமைனிங் ஆல் யூ ஹேவ் டு கோ அண்ட் ஃபைல் த பிடிஷன் அண்டர் ப்ராவின்சியல் இன்சால்வென்சி ஆக்ட் பிடிஷன் ஃபைல் பண்றோம். Two types of insolvency. What are they? Corporate insolvency. Second one is good individual insolvency, right? So technically, bankruptcy occurs when a court has determined insolvency and given legal orders for it to be resolved. Okay, all right. Now, bankruptcy is a determination of insolvency made by a court of law with resulting legal orders intent to resolve the insolvency. Insolvency describes situation where debtor means who has taken money. Debtor is unable to meet his or obligations. Bankruptcy is a legal scheme in which an insolvent debtor seeks relief. In case of insolvency, one cannot pay off the debts, whereas in the case of bankruptcy, a court order states as how an insolvent person or business has to pay off their debts, that is by way of selling their assets or erasing the debt that cannot be paid. Normally debts வந்து நீ கடன் அடைக்கலாம், கடன் அடைக்காதப்ப என்ன பண்ணுவா தெரியுமா, banks they will write off their debts. For example, Vijay Mallya is there, డబ్బులు పే చేయలే, బ్యాంక్ బ్యాలెన్స్ షీట్ లో ఏం చేస్తారు వాళ్ళు, దే విల్ రైట్ ఆఫ్ దేర్ డెట్స్. దట్ మీన్స్ ఇది நமக்கு வராது இன்னொன்னு சொல்லி they will write off their debts. Right now this is the mechanism under insolvency and bankruptcy board. For example, you know SEBI is there. SEBI என்ன தெரியுமா, very good, Securities and Exchange Board of India. It's a regulator of capital markets, right? நம்மளுக்கு இங்க கூட ஒரு போர்டு இருக்கு, அந்த போர்டு என்ன சொல்லுவாங்கன்னா Insolvency and Bankruptcy Board of India. You have to remember this terminology, Insolvency and Bankruptcy Board of India ஒரு போர்டு புதுசா எஸ்டாப்ளிஷ் பண்ணா. Now அதுக்கு யார் யார் இருப்பான்னா three types of agencies, they will conduct the insolvency process. Previous law யார் conduct பண்ணுவான்னா official liquidator will be there. Official liquidator. Now under insolvency and bankruptcy code, three types of mechanisms has been there. First one is information utilities. They will have all the information with respect to your debt. For example, the bank you take a personal loan, immediately that will be information will be given to information utilities. They will be having all your information like CIBIL. You know CIBIL என்ன information எல்லாம் இருக்கும், credit bureau. அதே மாதிரி நம்மளுக்கு ஒரு information utility is there. Whenever you are taking a loan, that information will be given to information utility. அவங்க கிட்ட எல்லா mechanical data மொத்தம் digitally they are having your data. Second type is insolvency professional agencies. Second type of mechanism என்ன, insolvency professional agencies. They will conduct the insolvency process. அவங்க தான் conduct பண்ணணும். Advocates conduct பண்ணணும்னா you have to practice 10 years. 10 years of practice இருந்தா you can become an insolvency professional. Now only 3 agencies has been recognized under this act. First one is Institute of Chartered Accountants of India. That means chartered accountants can conduct the insolvency process. First one yaru anna Institute of Chartered Accountants of India. Second one is Institute of Company Secretaries of India. Third one is Institute of Cost and Management. Ingredient in this is 180 days. 180 days குள்ள என்ன பண்ணணும், company assets எல்லாம் வித்து liabilities எல்லாம் கூட you have to settle. That means within 6 months entire process will be over, plus one extension of 90 days கொடுப்போம். 180 days குள்ள process complete பண்ணலன்னா again you will be given 90 days. That means 180 days plus 90 days entire company will be liquidated. For example, Vijay Mallya has taken money and he went to where, England. Previously என்ன பண்ணணும்னா அவனுக்கு நோட்டீஸ் அனுப்பணும், அவன் வரணும், அதெல்லாம் ப்ராப்ளம். இப்ப எல்லாம் ஒண்ணும் கிடையாது. You stay back in England, you don't worry, we will take care of your assets. நீ அங்கேயே ஒரு ப்ராப்ளம் இல்ல. நாங்க என்ன பண்ணுவோம், உன் assets எல்லாம் we will sell the assets, take back the money. That means within 180 days plus 90 days we will complete the entire process. Right? Let us recapitulate. right? Under the old act, High Court is having jurisdiction. They are known as adjudicating authorities. Under the new act, National Company Law Tribunal, National Company Law Appellate Tribunal, they are the adjudicating authorities. Mechanisms are Insolvency and Bankruptcy Board of India, Information Utilities, Insolvency Professional Agencies, and Insolvency Professionals. Is the adjudication authority. Debt Recovery Tribunal, DRT, is the adjudication authority with respect to individual insolvency and insolvency of partnerships. Right. From Debt Recovery Tribunal to Debt Recovery Appellate Tribunal, you are going for appeal. With respect to insolvency of LLP, Limited Liability Partnership, corporate insolvency, you are going before National Company Law Tribunal, National Company Law Appellate Tribunal, and in both the cases, appeal lies to Supreme Courts. Right? இப்போ ஹை கோர்ட்டுக்கெல்லாம் பவர்ஸ் கிடையாது. என்சிஎல்டிக்கு போனோம், என்சிஎல்டிக்கு போனோம், சுப்ரீம் கோர்ட்டுக்கு போனோம், டிஆர்டிக்கு போனோம், டிஆர்ஏடிக்கு போனோம், சுப்ரீம் கோர்ட்ஸ், யூ ஹாவ் டு கோ. Right. Where? Tomorrow. Right? Got something today? கிளாப்ஸ் அடிச்சா திருப்பும் கிளாஸ் எடுப்பா half an hour. பரவாயில்லையா? ரைட். All right. USB drive D, yeah? No. So I will show you. Yeah, please. Where it is? Jurisprudence. Okay. இல்லம்மா அது ஒரு பென் டிரைவ்ல you can send to separate folder there. Okay. Where it is installed, I hear this. Okay, new code. You write, you name it insolvency and bankruptcy laws. Insolvency and bankruptcy laws. Thank you. Right. Right, thank you. Hold on. ரைட், தேங்க்யூ. அது உங்க கண்ட்ரை கரப்ட் ஆயிடுச்சு, அப்போ திருப்பி இது பண்ண ஃபார்மேட், அவ்வளவுதான் அவ்வளவுதான். நீ பேரு கூப்பிடுறியா? ஒருத்தர வருவாங்க, பேரு கூப்பிட்டா வருவாங்களா?
కంపెనీ పెట్టి ఒక 2 years అయిపోయింది, ఏమీ చేయాల, అందులో కంపెనీ క్యాపిటల్ కూడా లేదు.
నువ్వు ఏం చేయాలంటే గవర్నమెంట్ కంపెనీగా స్టేటస్ తీసుకోవాలా.
గవర్నమెంట్ కంపెనీ
స్టేటస్ తీసుకోలేదు అనుకో, ఈ కంపెనీ